The concept of novelty as a concept has not been defined in patent law, but Section 21J talks about new product or process. At the same time, Section 21L defines new invention. As per this, a new invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. That is, the subject matter has not fallen in public domain or that it does not form part of the state of the art. Before going in depth of this, we need to understand that in order to obtain a protection, an invention should be hidden from general public before applying for the protection. Therefore, novelty means a new invention or something which is unusual. One of the primary requirements of novelty that the invention should not have been anticipated. In patent law, anticipation refers to the prior invention or disclosure of the claimed invention by another person or by the inventor himself. And this disclosure can be by either offer for sale or by publication or by any other means. Section 29 to 33 gives us 5 exceptions to the anticipation. Section 29 provides that following prior publications shall not be taken into account for determining the state of the art. First one being specifications made before 1912. An invention shall not be deemed to have been anticipated if the invention is published before 1st January of 1912. Section 29 Clause 2, where the subject matter was obtained without the consent of the patentee, or where the patentee learned about prior publication and made application within reasonable time, such application would not be deemed to be anticipated. Another case is complete specification has been filed in pursuance of an application for a patent. In such cases, the complete specification would not be deemed to be anticipated. Anticipation by previous communication to government. Section 30 states that communication of an invention to the government or to any person authorized by the government to investigate the invention will not amount to anticipation. Section 31. Anticipation by public display. Section 31 provides for 4 kinds of disclosures pertaining to inventions displayed in exhibition or disclosures to a learned society, which will not amount to anticipation of an invention. First one being display of an invention at such industrial or any other exhibition which have been notified by the central government under the Patents Act will not amount to anticipation. Similarly, publication of the description pursuant to such use has also been exempted for the purpose of anticipation. Where, consequent to such display or use in an exhibition, if an invention is used by any person without the consent of the true and first inventor, such use will not amount to anticipation of the invention. Furthermore, if an invention is disclosed pursuant to a description of it in a paper and the application for the patent has been made within 12 months after such disclosure, then such disclosure will not lead to anticipation. It is pertinent to mention here that prior to such disclosure at any exhibition or disclosure under Section 31, the inventor has to apply for the patent within 12 months from the date of such disclosure. Anticipation by public working. Section 32 provides that an invention shall not be deemed to have been anticipated by reason that at any time within 1 year before the priority date of the relevant claim, the invention was publicly worked in India for the purpose of trial. Section anticipation by use and publication after provisional specification. Section 33 provides that after the filing of the provisional specification, the publication or use of the invention anywhere in the world will not be deemed to have been anticipated. In the next video, we'll be looking at the concept of inventive step and utility. In the meanwhile, don't forget to like, subscribe, and share this channel.